The Supreme Court document that was supposed to remain sealed for 18 months just appeared on the federal court system's public database at 11:47 p.m. on January 3rd. Not because of a Freedom of Information Act request, not because of congressional oversight. The document upload was automated and nobody caught it until morning. Chief Justice Roberts' office said it themselves. We are investigating the circumstances surrounding the unauthorized disclosure of sensitive judicial documents. Translation: someone screwed up, and now the public knows about a federal investigation that was supposed to stay hidden until after the 2026 midterms. I'm Elizabeth Carter, and this is Real Politics Today. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell, leave a comment below telling me whether you think federal investigations of this magnitude should ever be kept secret from the American people. Share this video with everyone you know. This is the only official channel, and what I'm about to show you is happening in real time across Washington, and it's spreading. What was in that document? Docket number 25 CV 8834. A sealed motion for protective order in an ongoing federal investigation spanning 3 agencies: the FBI, the Department of Justice Criminal Division, and the Treasury Department's Financial Crimes Enforcement Network. The motion requested continued secrecy for what legal experts are calling the most comprehensive federal investigation into political finance violations in modern American history. But wait, there's something they're not telling you. This wasn't the only document that got accidentally published. At 11:52 p.m., 5 minutes after the first leak, 17 additional case files appeared in the public database before being pulled down 3 hours later. Think about that. 3 hours. Every major news organization in Washington monitors federal court filings automatically. Every investigative reporter, every political opposition research team, every foreign intelligence service with an internet connection. The cat is out of the bag, and it's not going back in. Here's what nobody is saying out loud. This investigation has been running for 18 months without a single leak, without congressional notification, without public awareness, until now. And this is where it becomes undeniable. Here's the core argument tonight in plain language. A federal investigation targeting the highest levels of American political finance has been running in complete secrecy for 18 months. This isn't about politics, it's about accountability. And tonight I'm going to walk you through the timeline, the legal maneuvers, and the institutional silence so you can see exactly how government transparency dies in real time. The investigation began on July 15, 2024. We know this because buried in the accidentally released court filings is a reference to Case Opening Report 2024, FBI CR 7749. The initial sealed warrant application was filed in the Eastern District of Virginia. Judge Patricia Williams granted emergency sealing orders on July 22nd, renewable every 90 days. Since then, 17 renewal applications. 17 times, federal prosecutors convinced a federal judge that public awareness of this investigation would cause irreparable harm to national security. First domino. The Treasury Department's Financial Crimes Enforcement Network flagged suspicious activity reports totaling $847 million in political transactions between January 2023 and June 2024. Second domino. The FBI Counterintelligence Division opened parallel investigations into foreign election interference after cross-referencing those financial patterns with known foreign intelligence operatives. Third domino. The Department of Justice Criminal Division convened a grand jury in Alexandria, Virginia, issuing 43 subpoenas to banks, political action committees, and technology platforms. Translation: the federal government has been building a massive criminal case involving foreign money, election interference, and financial fraud, and they've been doing it in complete darkness. Dr. Rebecca Martinez, constitutional law professor at Georgetown University, told the Washington Legal Review, "The scale of secrecy in this case is unprecedented in modern federal criminal procedure. When investigations of this magnitude proceed without congressional oversight or public accountability, we're not just hiding evidence, we're hiding the very existence of potential threats to democratic institutions. Let that sink in. This is not normal federal criminal procedure. Standard Department of Justice policy requires congressional notification of investigations involving elected officials within 30 days of initiation. That notification never happened. The pattern is clear. In March 2024, similar sealed investigations targeted municipal corruption in Detroit. In August 2024, sealed federal financial crime probes launched in Phoenix and Atlanta. In November 2024, emergency sealing orders covered federal election interference investigations in Pennsylvania and Georgia. All sealed, all secret, all proceeding without public oversight. Professor Martinez continued, what we're witnessing is the systematic use of national security exemptions to shield domestic political investigations from democratic accountability. The precedent this sets for future administrations is genuinely terrifying. Think about that. And then it got worse. January 4th, 6:18 a.m., White House Deputy Chief of Staff Michael Torres received an encrypted briefing document titled Priority Alpha Legal Exposure Assessment. By 7:45 a.m., Torres had convened an emergency legal strategy session with White House counsel Patricia Kim and 4 senior Justice Department officials. January 4th, 11:30 a.m., House Speaker Mike Johnson received a classified briefing from FBI Deputy Director Sarah Chen. Duration, 47 minutes. Johnson's office immediately canceled all scheduled media appearances for the remainder of the week. January 4th, 2:15 p.m. Senate Majority Leader Chuck Schumer and Minority Leader Mitch McConnell held a rare closed-door bipartisan meeting. No staff, no notes, no official record. The meeting lasted 2 hours and 33 minutes. January 4th, 4:47 p.m. Department of Justice spokesperson Maria Rodriguez issued a statement. The department does not comment on ongoing investigations or sealed proceedings. We remain committed to following the evidence wherever it leads while protecting the integrity of the judicial process. Translation: we've been caught hiding a massive investigation, and we're going to keep hiding it while pretending this is about protecting justice. January 5th, 9:22 a.m., Senate Intelligence Committee Chair Mark Warner requested an emergency closed session for January 8th. The agenda: executive branch notification protocols regarding domestic security investigations. Translation: Congress just found out they've been completely cut out of oversight on a case that could reshape American politics. January 5th, 1:14 p.m., Federal District Judge Patricia Williams issued an emergency order resealing all accidentally disclosed documents. But here's the irony: the internet never forgets. Legal researchers across the country had already downloaded and archived every page. January 5th, 3:28 p.m., the Treasury Department's Inspector General announced an internal review of document handling procedures. Meanwhile, 17 major news organizations filed emergency motions demanding full disclosure of the investigation's scope. January 6th, 8:45 a.m. This next part is going to blow your mind. The accidentally released court filings revealed not one investigation, but 4 separate federal criminal probes running simultaneously. Case numbers 2024 FBI CR 7749, 2024 FBI CR 8821, 2024 FBI CR 9334, and 2024 FBI CR 9856. 4 different grand juries, 4 different federal prosecutors, 4 different sets of sealed evidence. The scope is staggering: foreign election interference, domestic political finance violations, money laundering through political action committees, and conspiracy to defraud the United States. January 6th, 12:17 p.m. Republican Senators Ted Cruz, Josh Hawley, and Marco Rubio jointly demanded that Attorney General Merrick Garland testify before the Senate Judiciary Committee within 72 hours. January 6th, 2:33 p.m. Democratic Representatives Alexandria Ocasio-Cortez, Jamie Raskin, and Adam Schiff issued a statement calling for immediate declassification of all non-sensitive portions of the investigation. Bipartisan outrage. Think about that. January 6th, 4:55 p.m. The Federal Bureau of Investigation issued its first public statement. The FBI conducts investigations according to established legal procedures and Department of Justice guidelines. We do not confirm or deny the existence of ongoing investigations. Translation: yes, these investigations exist, but we're going to pretend they don't while scrambling to control the damage. January 7th, 7:30 a.m., constitutional law professors from Harvard, Yale, Georgetown, and Stanford law schools published a joint letter in the Washington Post. The systematic concealment of federal investigations involving political figures represents a fundamental threat to democratic accountability. Congress must act immediately to restore transparency, and this is where it becomes undeniable. Let me tell you about Sarah Chen, federal courthouse reporter for the Washington Legal Tribune, 23 years covering federal criminal proceedings. Chen noticed something unusual starting in July 2024, an unprecedented number of sealed motions being filed in the Eastern District of Virginia, all with the same emergency classification codes. Chen told Legal Affairs Weekly, "I've covered thousands of federal cases. I know the rhythm of the courthouse. When you see 17 sealed emergency motions from the same prosecutor's office in 6 months, all with national security classifications, you know something big is happening. But this level of secrecy was unlike anything I'd ever witnessed." Chen started tracking the pattern: emergency hearings scheduled for 6 a.m., closed courtrooms with additional security, federal marshals escorting unidentified individuals through back entrances, court reporters sworn to extraordinary confidentiality agreements. Let that sink in. And Sarah Chen is not alone. Court reporters, legal clerks, and federal courthouse staff across Virginia, Georgia, Pennsylvania, and Arizona have been operating under gag orders for months, prohibited from discussing even the existence of proceedings they've witnessed. Let me tell you about David Martinez, former Department of Justice attorney, 1987 to 2019, specialized in public corruption cases. Martinez predicted this exact scenario in a Harvard Law Review article published in March 2023. Martinez told the Constitutional Accountability Project, "The danger of using national security exemptions to shield domestic political investigations is that it creates a two-tiered justice system. When the American people cannot observe how their government investigates political figures, democracy itself becomes the casualty. We're witnessing the normalization of secret justice." Think about that for a moment. Martinez has been tracking the use of emergency sealing orders in federal courts since 2020. His research documents a 340% increase in sealed political investigations since 2021, with average secrecy periods extending from 90 days to over 18 months. This is not abstract. This is real. Let me tell you about Lisa Thompson, Executive Director of Government Transparency Watch, a nonpartisan organization that monitors federal accountability. Thompson has been filing Freedom of Information Act requests for basic information about sealed court proceedings since the first documents leaked. Thompson told Democracy Now!, "The American people have a right to know when their government is conducting investigations that could fundamentally alter the political landscape. We're not asking for evidence or witness names. We're asking for basic acknowledgement that these investigations exist and what legal authority justifies keeping them secret from Congress and the public." Thompson's organization has filed 47 FOIA requests with the FBI, Department of Justice, and Treasury Department. Response rate, 0. Every request has been denied under national security exemptions. Every appeal has been rejected. Every attempt at judicial review has been blocked by the same emergency sealing orders that started this crisis. Let that sink in. And Lisa Thompson is not alone. Citizens across the country are demanding answers through legal channels, only to be told that even asking questions about secret investigations threatens national security. The pattern is undeniable. Government transparency advocates in Michigan, Wisconsin, Nevada, and North Carolina report identical stonewalling when requesting information about federal political investigations in their states. What does this mean for ordinary Americans? When federal investigations of this magnitude proceed in complete secrecy, citizens lose the ability to hold their government accountable for how justice is administered. Translation: your government is investigating political figures using your tax dollars, making decisions that could reshape American democracy, and you're not allowed to know it's happening. How does a federal investigation involving foreign election interference, $847 million in suspicious financial transactions, and 4 separate grand juries remain completely hidden from Congress and the American people for 18 months? The answer lies in a legal loophole that has transformed national security exemptions into a shield for domestic political investigations. Under Title 18, Section 793 of the U.S. Code, federal prosecutors can request emergency sealing orders when disclosure would compromise ongoing intelligence operations. Originally designed to protect foreign intelligence assets, this authority has been systematically expanded to cover domestic political cases. Fourth domino, emergency sealing orders bypass normal congressional notification requirements when prosecutors invoke national security classifications. Fifth domino, federal judges operating under sealed proceedings cannot independently verify whether national security claims are legitimate without access to classified briefings. Sixth domino, congressional oversight committees are legally prohibited from reviewing sealed cases unless specifically briefed by the executive branch, which controls the classification process. Translation: the executive branch can investigate itself in complete secrecy by claiming national security, and no other branch of government has the legal authority to challenge that claim. Dr. Michael Roberts, government accountability scholar at the Brookings Institution, published an analysis in the Yale Law Journal documenting this systematic expansion. Since 2019, federal prosecutors have invoked national security sealing orders in 73% more domestic political cases compared to the previous decade. The average secrecy period has increased from 4 months to 16 months. Congressional notification has dropped from 89% to 12% of cases. Think about that. Congressional oversight of federal political investigations has collapsed by 77 percentage points in 5 years. But here's where it gets truly alarming. What happens when this becomes the standard operating procedure for every administration? If the precedent holds, future presidents could initiate federal investigations against political opponents, seal them under national security classifications, and proceed without congressional oversight or public accountability for years. That is not theoretical. That is the legal framework being established right now. However, transparency has prevailed before. In 1974, the Church Committee forced disclosure of classified FBI political surveillance programs. In 1987, congressional pressure unsealed the Iran-Contra investigation. In 2016, public demands led to partial disclosure of foreign election interference investigations. In each case, sustained public pressure and congressional action overcame executive secrecy claims. The mathematics are stark. Federal courts processed 2,847 sealed motions in political cases during 2024, compared to 891 in 2020. That represents a 219% increase in government secrecy around political investigations. Success counterexample: when federal prosecutors attempted to seal the Paul Manafort investigation in 2017, congressional oversight and media pressure forced partial disclosure within 6 months. Public accountability mechanisms functioned as designed. Translation: the system can work when citizens and their representatives demand transparency. And here's the irony. Current federal transparency laws, including the Freedom of Information Act and congressional oversight statutes, were specifically designed to prevent exactly this type of secret political investigation. Professor Roberts concluded, "We are witnessing the systematic dismantling of post-Watergate accountability mechanisms through the misuse of national security classifications. Unless Congress acts within weeks to restore transparency, we will have created a legal framework for secret political justice that any future administration can exploit." What happens in the next 72 hours will determine whether American democracy retains the ability to observe how its government administers justice. Here's the accountability question I want you to answer in the comments. Should federal investigations involving $847 million in suspicious political transactions, foreign election interference, and potential conspiracy to defraud the United States be allowed to proceed in complete secrecy for 18 months without congressional oversight or public disclosure? Yes or no? Binary choice. Because this is not about protecting legitimate national security interests. This is about whether American citizens retain the right to observe how their government administers justice when political figures are under federal criminal investigation. As of this recording, January 7th at 9 p.m. Eastern, here's where we stand. 4 federal grand juries continue meeting under seal. 17 major news organizations have filed emergency disclosure motions. The Senate Intelligence Committee has scheduled emergency hearings for January 8th, and the accidentally leaked documents remain under emergency resealing orders that may never be lifted. Translation: The next 48 hours will determine whether this investigation returns to complete darkness or faces the public accountability that democracy requires. What does your action mean? When you share this video, when you contact your representatives, when you demand answers from your government, you are exercising the constitutional principles that separate democracy from authoritarianism. This is not abstract. Every view, every share, every comment creates public pressure that makes it harder for government officials to operate in darkness. I will be here following every development, every court filing, every congressional hearing, every attempt to restore transparency or maintain secrecy, because this story is being written in real time and you have the power to influence how it ends. Subscribe to this channel, hit the notification bell, share this video with everyone you know. Leave your answer to the accountability question in the comments below. I read every single response and your engagement shapes which stories I investigate next. The Supreme Court document leak was not an accident of technology. It was a moment when democratic accountability briefly broke through institutional secrecy. Whether that moment leads to lasting transparency or deeper concealment depends on what citizens do right now. Contact your representatives, demand congressional hearings, support transparency organizations, exercise the democratic rights that previous generations fought to establish and protect. Because this story is not about politics, it is about people. It is about whether ordinary Americans retain the constitutional right to observe how justice is administered in their name, with their tax dollars, affecting their democracy. The next chapter in this story starts with your voice.